Judge Murphy in the Wine W. Melly trial granted the state's motion to extend the trial back to February 5th. Last week, Murphy also granted the defense's motions to have the jury struck. So now they're completely restarting with selecting the jurors who will participate in the trial. The defense team filed a motion to suppress all evidence from a search warrant on Melly's phone in 2019. Yeah, I've been gone for a week, so I'm finally back making videos, boys. This trial is not starting until February now. Such a bummer. I wanted to get this over with in January and February, but now it's looking like February and March. But yeah, I'll keep covering this. If you're on my channel, subscribe from Twitter and Instagram. Let's get it, boys. All right, so we got restriking jury panels due to defense misstatement of the law. So they're saying the defense said something they weren't supposed to say in front of the jury. Jury selection started on October 18th. State previously requested the court commence jury selection and bring back on January 8th. Okay. After approximately 2 weeks of time qualifying jurors, attorney questioning began on November 6th, so 10 days ago. State spoke to the first group of prospective jurors in part on Monday, November 6th, and finished this portion of voir dire on Tuesday, November 7th. I saw Lil Uzi live about 2 hours ago and it was incredible. Bro had one of the most interesting set designs I've seen in recent years. And he played all his old shit and his new stuff as well. He interacted with the crowd a lot, caused like chaos. If you live in Boston, DC, Philly, or Brooklyn, New York, go to the Uzi show. Use my link down below. It's the safest link possible. He was up there for like an hour and a half tonight, so it was fucking sick. Use my link below. Buy tickets right now. Defense counsel began on November 7th. Okay. During defense counsel's voir dire, counsel improperly informed the jurors that the state must prove all the elements of the crime, including defendant's gang associating beyond a reasonable doubt in order for the defendant to be found guilty. Okay. The state objected to misstatement of the law, a valid legal objection, and the court requested a sidebar. During that initial sidebar, counsel was told to rephrase the question. Defense counsel subsequently read the indictment to the jurors, which includes the gang enhancement language, and again indicated to the prospective jurors that the state has the burden to prove all of the elements, including gang enhancement, beyond a reasonable doubt in order to be found guilty. So one of Melly's lawyers basically said to the jury they have to prove his gang association when they should have worded it saying his gang enhancement language. That's the only difference. So clearly Melly's lawyer fucked up, but it doesn't seem like it's that big of a deal. And Melly's team is the reason why this all happened too. Like they wanted to strike the jury and get rid of them and start over. Melly's team did, not the state. The state once again objected to the misstatement of the law. In addition, a juror asked for counsel to clarify, asking, "Are you telling me that if we find the defendant killed the victims, but not that it was a part of the gang, that he's not guilty?" Oh, okay. So yeah, I could see how that could be tricky. So apparently they weren't supposed to say any of this, actually. This could confuse a juror saying, well, I don't think he was in a gang, but I do think he killed them. That could be tricky for a juror in this situation because death penalty is on the table, which means they have to prove that it was in furtherance of a gang. Another sidebar was held where the state requested the court read the jury instruction to the jurors, which would clear up any confusion. Defense counsel objected to the court reading the instruction and vehemently argued to the court that because the state placed the language in the indictment, it becomes an element. Kind of a good point. The prospective jurors were removed from the courtroom for further argument to take place. In the defense counsel's argument to the court, it became apparent the defense was under the misplaced impression that the gang language cited to the indictment was regarding the gang aggravator under FS. Okay, don't know what that means. Counsel for the state pointed out the state does not put aggravator language in indictments for penalty phases of the trial. However, we do in fact place enhancement language in indictments. Okay. Counsel for the state also made it abundantly clear that enhancement language goes towards interrogatories of a verdict form and that the defendant can be found guilty of 2 counts of first-degree murder whether or not the jury finds the gang enhancement. Okay. The state once again simply asked for the jury instruction to be read to the court, something that is routinely done in jury trials throughout the courthouse in the state of Florida when a valid legal objection is made. The court agreed with the state and ruled the instruction would be read. Due to the court's ruling, defense counsel moved to strike the entire panel, as he would lost all credibility with the jurors should the court read that instruction. Basically, Melly's team was starting to be careful about what was read to the jury because they didn't want to taint their mind in any way and make them second guess if they were to do a not guilty ruling, basically. The court allowed counsel to confer with the defendant, and despite the state's objection that this is not grounds for striking an entire panel, the court granted the defense motion to strike the panel. Wow. So the state did not want to do this because it was clearly like a good thing for the state to be able to read that to them and, you know, clarify, yo, if you don't even think he's in a gang, you can still put guilty. The state fears that every time the state objects, instead objection is sustained, the defense will move to start over because it affects their credibility with the jurors. For centuries, the rules of evidence have existed and lawyers on both sides have objected in front of jurors where they were either sustained or overruled. It's also quite common for lawyers to misstate the law during voir dire, at which time courts have consistently jumped in and read the jury instructions. The state is saying that Melly's team kind of over-exaggerated everything and got rid of the jury when they really didn't need to, but I understand why they did it. Is it a little excessive? Maybe, yeah. Furthermore, a total of 3 jurors have now come forward regarding improper conduct by both known and unknown individuals. What? Improper conduct. The state has expressed serious concerns for the integrity of the jury selection process, this case, and the judicial system as a whole. The state did not move to strike the panel despite the grave concerns that it has for jury tampering. The state merely asked for the jurors to be questioned in accordance with the law. Yet, after a valid legal objection was sustained, the panel was struck at the request of the defense. While the state understands the court acting in an abundance of caution, objections being sustained and jury instructions being read by the court to rectify the misstatement of law should not rise the level of starting over. All this time being spent on jurors that have now been struck could have gone to both sides clearly need to further prepare for trial. The state does not want this to become a pattern where with each objection made, another group of jurors is struck. Wow. So the state's a little scared that they're going to keep doing this over and over. I doubt that because I feel like Melly's team wants to get this over with. They were just being really cautious in this situation. I'd be really shocked if they did this twice. On November 7th, 11 days ago, the state gave a USB of cell phone carrier records to the defense. So we got a document from the defense right here. Amended suppression motion number 11. Amended motion to suppress evidence obtained through search warrant for Apple iPhone X. Any and all evidence seized and provided to law enforcement pursuant to the warrant authorizing the examination of Apple iPhone X with serial number blah blah blah. So it talks about Cortland dropping the bodies off and everything as part of the investigation. Affidavit for search warrant was prepared on March 7th, 2019. Okay. There was no probable cause to believe the existence of the grounds on which the warrant was issued. The warrant is insufficient on its face. No probable cause to believe the existence of the grounds of which the warrant was issued. There's no indication in the affidavit as to how long he has been a law enforcement officer. Talking about Detective Mark Moretti. I'm not sure whose phone this is. I don't know if this is Melly's phone or one of the phones that they found in the back seat, like on the floor maybe. I'm not sure. They're talking about Melly's phone, right? The affidavit fails to state whether Moretti has any familiarity whatsoever in homicide investigations. Affidavit fails to indicate what training, experience, or education he has had, and not only in homicide investigations, but also in cell phones or computers. Quote, data shows that the computer hard drive software and electronic files may be vital to criminal investigations in two distinct ways. What data? From whom? As part of the training? Question mark. Phishing data? Question mark. Upon experience? Question mark. The technical requirements. Quote, although the affidavit goes through the lengths for the technical requirements needed to extract the information contained in the device, there's nothing in the affidavit to support how Moretti has the knowledge to put the paragraph in the affidavit. So they're saying this warrant shouldn't have happened, and there was no legal basis for it to happen, for whatever phone this is. I think it's Melly's phone. The ability to undelete files. There's nothing in the affidavit to explain how Moretti, who signed the affidavit, has knowledge of what is contained in this paragraph of the affidavit. The affidavit contains information that was provided through the search warrant for cell site cell phones for Mr. Demons. It also contains information as to cell phone mapping, which was derived from the cell phone cell site information. The affidavit also contains CDR information that was gleaned from T-Mobile cell phone records of Mr. Demons. The cell phone itself was seized unlawfully by the law enforcement, as it was not the item referenced to be seized under Judge Colra's February 28th, 2019 warrant as fruits of the poisonous tree from the illegal search and seizure of Mr. Demons. These references in the affidavit must be excised, and if the probable cause still exists, needs to be determined by this in court. Okay, so here's a good list right here. In order to establish the probable cause, the affidavit relies upon evidence and fruits of the poisonous tree from the search warrant obtained on the cell phone cell sites used by Demons, cell phone mapping, cell site data, T-Mobile cell phone records of Demons, the search warrant of the Snapchat account of Demons. Without these items seized in previous searches, under previous warrants, there would not be probable cause for the issuance of this warrant. Although the description of the items to be searched is an Apple iPhone X, it was actually the tip of the iceberg of what the search warrant allows. Without delineating item by item what was contained in the affidavit and the warrant attached here too, the warrant allows the seizure of computer equipment and storage devices or magnetic, like electronic or optical storage devices, encryption devices, keys necessary to gain access to the computer equipment. Okay. The warrant is a general warrant, overbroad, and therefore in the violation of 4th Amendment to the United States Constitution. It acknowledges that the entire contents of the phone and other items seized under the warrant will be taken to the law enforcement laboratory for review. After reviewing all the data, they will extract and seize what they determine falls within the list of items seized. So what it sounds like is the state found out more shit than they should have found out in a search warrant, and they're saying they shouldn't have got the search warrant in the first place, and it was too broad, and they don't want it in the fucking trial. Will it happen? No. Fuck no. The judge is gonna let in the trial. Not gonna happen. The warrant does not define who the computer personnel are, other than we know that they are law enforcement, as the seized items are to be taken to the law enforcement laboratory. Reasons for suppression. The affidavit in this case is legally insufficient. Therefore, there was no probable cause for the existence of the grounds on which the search warrant was issued. Violates the defendant's 4th and 14th Amendment rights to be free from unlawful search and seizures. Ellie's mom posted, "I'm sorry, kid," heartbreak emoji, crying because of his trial being pushed back an extra month. Y'all act like he doing easy time. He doesn't have phone calls or visits like most people in jail, not to mention 23-1 lockdown. So yes, I feel sorry for my kid and whoever else family's hurting this holiday season. Yeah, some people will feel bad for her and some people won't. I have to admit I do a little bit just because, you know, I've met her and talked to her a little bit, but it's a tragic situation. I also feel bad for the families of the deceased victims as well. So just how it is naturally.